Good afternoon, everyone. I welcome all the participants who have joined us for today's webinar session, where we will be discussing what are the provisions for the recovery of outstanding payments for MSMEs under MSME Act and IBC, Insolvency and Bankruptcy Code. Today, we have with us Dr. H.P. Kumar. He is the former CMD of National Small Industries Corporation and also Director External Affairs at Power to SME. We have Mr. Aryan Arora from Sapphire Sage Law Offices, and we have Mr. Shrey Patnaik. He's a Associate Director at Sapphire Sage Law Offices. So, before I hand over the session to Dr. Kumar to take the discussions forward, I would like to take the participants to the profile of the organizer, which is Power to SME. Power to SME was established in the year 2012 by our founder and CEO, Mr. R. Narayan. He came up with a very innovative business model which eliminated the intermediaries in the supply chain of commonly used raw materials from the big manufacturers to the MSME manufacturers. And he did that on the demand aggregation model, and thus we were able to provide better pricing to the MSMEs. Mr. R. Narayan is also the current president of FICCI CMSME, which is the MSME body within FICCI. This is the Power to SME ecosystem. As I mentioned, Power to SME, it provides raw material at a very competitive rate. Our brand SME Shops, it offers, it's a B2B portal for the maintenance, repair, and operational goods, the industry consumables. We also have our own NBFC by the brand name Disfunds, which facilitates the purchase financing options to the MSME. And we have our branch Finance Me, which connect MSMEs with the empaneled financial institutions for raw material requirements, capital requirements. The key product categories that we deal in include steel, polymer, paints, yarn, chemicals, and there are many more. The major industry segments that we cater to includes auto components and ancillaries, electronics, engineering, infrastructure, plastic, and there are several others. Power to SME is your one-stop shop for all the needs for the manufacturing MSMEs, right from the raw material to the purchase financing. We are an invested company. Some of the most reputed venture funds in the country have invested in us. Inventors Capital, Kalari Capital, Excel Partners. Nandan Nilekani is one of our strategic investors. We are also funded by World Bank through its financial arm, International Finance Corporation. These are the awards and accolades that we have won since our inception. And this is our online presence. Any one of you want more about our services can get in touch with us through any of these mediums. And if any participant has any questions or queries to be asked to the speakers, you may submit your questions in the chat box. These questions will be taken up to the session chair, Dr. H.P. Kumar, in the Q&A session. So now I would like to invite Dr. H.P. Kumar to kindly begin the discussion. Over to you, sir.
Thank you, Mr. Zubair. Thank you very much. In fact, it's a very interesting session where we are going to deliberate on the recoveries of outstanding payments of micro, small, and medium enterprises. And we will discuss, in fact, in this session as to what is the problems, what are the provisions in the acts, MSME Development Act, as well as IBC provisions, and why these recoveries are not taking place, what are the major causes, and of course, some of the recommendations which can be made to the government and other concerned stakeholders as to how do we address these problems. So it's going to be very interesting. I'm happy that we have two experts available on these, for these discussions. The experts, I'll introduce them a bit later, but let me acknowledge their presence. Advocate Aryan Arora, who is the legal manager at Sapphire and Sage Law Offices. And welcome, Mr. Arora. And
thank you, sir.
Advocate Shrey Patnaik, who is an associate partner at Sapphire and Sage Law Offices. So both of them, of course, well equipped with the legal provisions and what is exactly facing this, MSME sector with regard to the constraints and how do we address these constraints, because we have been talking about these issues for a long time now. the act came, MSME Development Act came in 2006. And realizing this problem, we had, in fact, I was part of that formulation of that MSME Act when I was in the NSIC, heading the NSIC, being part of the Ministry of MSME. So we had realized that this problem was continuing for a long time, and we built provisions in the MSME Development Act that MSMEs are very vulnerable, in fact, when they supply to larger corporations, larger, of course, companies, or even their smaller buyers also, because with regard to MSMEs, it is the buyer's market always, not the seller's market. So they don't dictate their terms of payment. They have to somehow get the market and orders. So they can't fight with their buyers if the payments are getting delayed. So considering these provisions, in fact, we have built in the MSME Act, the Development Act, that maximum 45 days should be the window for clearing all the payments, and or agreed terms. Of course, if agreed terms is 15 days, 20 days, 30 days, 40 days, or on demand, say, so agreed terms should be followed. But when we were writing this provision, agreed terms, somebody said that, sir, agreed terms could be even 60 days, 90 days, 180 days, 120 days. So if you write only agreed terms, so even then there is a risk of MSMEs being exploited by their buyers and large companies. So we said, okay, agreed terms, but not exceeding 45 days. In any case, 45 days should be the maximum window. And beyond 45 days, if you are delaying the payments, you should pay interest. And interest also quite prohibitive at the rate of 3 times of the bank rate, which at that time was 6%. So it would amount to 18% per month, per annum, sorry, and compounded monthly. So these were the provisions built, but things did not, even Act provisions also did not make much impact. Of course, some impact is there, but then there is always a indirect way of, dealing with things. Then Act also provided, MSME Development Act, for setting up MSC facilitation councils. This is micro and small enterprises facilitation councils. Not the medium is not included in that. So in case of any disputes in payments, delays beyond reasonable doubt, or maybe reasonable period, or maybe if you are not able to recover the dues or interest, any other disputes, you can refer, micro and small enterprises could refer their problems and with the details of the overdue payments to the micro small enterprises facilitation council. These facilitation councils were set up in each state, were supposed to be set up, and they have been established now. And the council comprises of basically the district authorities, industry department, and normally director industries chairs that facilitation council. And then there are other members from the industry associations and industry itself. So these facilitation councils were basically supposed to deal with all the complaints of the micro and small enterprises with regard to delayed payments, and call the companies who were defaulters or the buyers who were defaulters, and then get the whole thing settled through arbitration or through their own mechanism of looking at the evidence and passing the orders. So this provision also proved to be, I mean, a way forward, but I would say not very fully effective 100%, that the people have started doing everything as per the law. So I was looking at the figures, in fact, in the Ministry of MSME website. Till now, in micro small facilitation councils, I found that 1,13,537 cases have been filed. 1,13,537. And out of 1,13,537, MSC facilitation councils have been able to dispose of only 16,505. 16,505. So 1,13,000 में से 16,505 cases disposal हो पाए, which is around 15%. So out of 100 cases filed, it's only 15 cases which have been disposed of by the MSC Facilitation Council. This is not my figure. This is the ministry's website. Anybody can see that. MSME समाधान के नाम से एक पोर्टल उन्होंने बनाया है. उसके अंदर ये डेटा सारा अपलोडेड है. I was a bit surprised to see that out of 1,13,000 cases, it is mentioned there 30,400 cases are yet to be viewed by the MSc facilitation councils. They are yet to see them. I mean, forget about the resolution of such cases, which is of course time taking, because you have to call for the buyers and evidence and establish that the due is really due. But then if you are not able to view the cases, how long it is going to take to dispose of such cases? So that is a bit surprising, but I don't know what is the reason that why the facilitation councils are not even able to view the cases, and disposal of course comes later when they take a decision. Maybe as the complaints and feedback comes from the micro small enterprises, that they are short of time, and meetings are held only once in a while, and the cases are so much that they are not able to devote full time, and that is how it gets delayed. So MSc facilitation councils also, as we expected, are not proving to be very fruitful. So how do we do it then? What is the way forward for settlement of these cases, for recovery of these cases? Another provision which the Government of India introduced for procurement by the government organizations and PSUs, government entities, is GEM, Government E-Marketplace. So that provision is a very good provision for removing the, corrupt practices, or maybe face-to-face delays, interactions, problems, and clean business. So GEM, of course, has proved to be very helpful and very useful. But then payments are even delayed there also on GEM platform also. If in the government departments and buying organizations, actually the provision is that within 10 days they should make the payments. And government has come out with, Ministry of Finance has come out with the provision. It is a provision issued, the notification issued in July 2020, 3rd July 2020. It's a Ministry of Finance memo, whereby they said that buying departments will have to pay late payment charges of 1% per month if they delay it beyond 10 days. And this 1% per month will be paid to GEM. GEM will create a fund, and this fund will be utilized for education of buyers and sellers. So we have represented to the government from the chambers that this 1% should be paid to the sellers, MSMEs, because they are the sufferers. If you recover 1% for delayed payment from the defaulting buying organizations and keep it with the GEM, MSCs are going to suffer, MSMEs are going to suffer, continue to suffer. So that also should be corrected. That is what we wrote to the Government of India. Now, these are the problems. Now there is another issue in IBC. Of course, I am not going to explain everything. We have experts sitting here. I would expect that they in fact come out with the clear provisions and what is the way forward. But briefly introducing and setting up the context, I thought let me take a few minutes in fact to open up the areas of discussion. So another IBC provisions also in fact put the micro, small and medium enterprises at the bottom of the chain, where payments will be released to MSMEs out of the whatever is recovered from the defaulting company. In case they are referred to under the IBC, they are referred to NCLT by banks, by the committee of creditors, and when they take a decision. So first is secured creditors, then unsecured creditors. Then MSMEs come under the operational creditors. So again, they are at the bottom. We represented to the government, in fact, even on this issue also, that there also, in fact, MSMEs should be given some priority, and in the mechanism, they should be, in fact, upgraded. And they should also be forming part of the committee of creditors. As of now, they are not. Now, some way forward that I think I would request my co-panelist experts, in fact, to throw some light, in fact, on these issues also, as to what is the way forward. How do we rectify? Because government has done by way of provisions, by way of act, by way of notifications, by way of setting up these mechanisms, but then things are not improving. Some of the areas where I thought that we could take action was that MSc Facilitation Council should be made more robust. They should be given more powers, and their decisions should be implemented without, like a decision of the court of law, like a decree. Instead of again going to the court for execution of such orders, they should be given powers of the judicial powers, and they should. I hope Mr. Arora would agree. And otherwise, the mechanism is toothless, because they will only issue an order or maybe a arbitration award, but then this arbitration award and order will have to be referred to again for the judicial intervention and taking a decree and then execution. So that is one way I thought maybe some help could come. And facilitation councils also should be strengthened by way of more members, more facilitation councils, so that they meet regularly. If not every day, at least once in a week, at least they should be able to meet, so that all pending cases can be cleared. Because as we see, 30,000 cases are yet to be viewed by them. So that is another recommendation which we made. In fact, there was one provision whereby, in order to remove these difficulties, TREDS was established, TREDS, Trade Receivable Discounting System, where the government said that all companies with 500 crore turnover plus should compulsorily all get registered. Well, 500 crore turnover is okay. Not all have registered even as of today also. But we have recommended that all companies which are non-MSMEs, that is beyond 250 crore, should be compulsorily asked, should be made to register TREDS, so that at least they as a buyers, their bills can be uploaded on the TREDS and MSMEs can get them discounted. If not timely payment is received, at least discounting is facilitated from the banks. So these are some of the suggestions. I have many other suggestions also, which we'll keep discussing, because I think let me give time and invite the experts, in fact, to speak about. We will continue to deliberate and discuss. And if there are any questions at a later stage, we'll take up those questions also. So first of all, let me invite Advocate Aryan Arora, Mr. Aryan Arora, who is the legal manager at Sapphire and Sage Law Offices, and where he leads the payment recovery team. He's an advocate who has broad experience in legal risk mitigation and has represented clients in courts and provided professional legal advice. Of course, he is the best person, in fact, to talk about these legal issues. So over to you, Mr. Arora.
Thank you very much, sir. Thank you for such a beautiful introduction. Thank you, everyone, for coming. So, as sir has already given so much insight about the MSMEs and the provisions that the Facilitation Council has made, he's also discussed so many issues that the MSMEs are still facing. Even after the MSME Council has been made and they're also working upon it, still there are many issues that are being faced by MSMEs. So today we'll talk about payment recoveries. Now, everyone should know that there is a difference between profit on books and actual profits that MSMEs have. So you might have good profits on books, but actual profits may vary. If this is the case, then you have to look into your payment recoveries. Then there might be some operational expenses that you might be suffering from. So today, these are the current numbers that the MSMEs are facing. So today we will discuss the modes of recovery of payments, not only for MSMEs, but what are the modes of payment recoveries. So the first mode of payment recovery is through specific performance. If you have a contract with you, then you can approach the court to get the contracts performed through specific performance. But usually, because MSMEs are very small units and they don't have contracts in place, so this is a very difficult thing for the MSMEs. The next thing that the government has provided is recovery suits. Recovery suits through commercial courts. So in this also, there is a very high court fees that has to be paid. Now, MSMEs are they're already suffering with so many financial problems. The recovery through commercial courts is very difficult. Then comes the Insolvency and Bankruptcy Code. So Shrey would be a better person who will guide you on the Insolvency and Bankruptcy Code. The fourth system is the MSME Samadhan Recovery Scheme. The MSME Recovery Scheme, we will discuss that today. So let's just simplify the act for you. First, let's discuss who are an MSME. So according to the latest definition, the investment of MSMEs for the manufacturing sector, the MSMEs who, the enterprises who have an investment less than 25 lakhs are covered in micro enterprises. But this is for the manufacturing sector we are talking about. Then comes the small sector. For the small enterprises, the investment in plant and machinery is less than 5 crores. If you have your investment less than 10 crores, then you are covered under medium enterprises. This is for the manufacturing sector. For the service sector, the investment is 10 lakhs for the micro sector. For the small sector, your investment on plant and machinery can be 2 crores, less than 2 crores. And for the medium sector, it has to be less than 5 crores. So the MSME scheme is just for the micro and small enterprises till now. So we will discuss today what are the provisions that the Act has specified. The Act says that what is a appointment date. So appointed date is the date on which the buyer who you have supplied your service, who you have supplied your goods or rendered your service has not made your payment within 15 days. If they have if they have not taken any objections within 15 days from the day of your supply of goods or rendering your services, then it is considered as deemed acceptance. Your contract may or may not have a clause of acceptance. If they have not made any objections to the quality of your goods or the quality of your services, then the Act has clearly specified that only 15 days in written he has to specify. The next thing that comes is the section 15 of this Act. This Act says that the buyer who you have supplied the goods has a liability to make the payment within 45 days from the date you have supplied the goods. And in case he has not made this payment, you are allowed to approach the MSME Facilitation Council. Now, before this, when does the interest liability start? The interest liability starts from the date of deemed acceptance, not from the date which you approach the council. So this is not only for the micro enterprises, but this service is also for the small enterprises. Now, what is the section 16 says? The section 16 of this Act says that you are from the date of which the interest is payable. Let's say you have supplied the goods today. From the 16th day from today, the interest will start calculating. And this interest, as Dr. Kumar has rightly said, that interest is compounded monthly, and the bank rate, the current bank rate, you are given 3 times the current bank rate. The current bank rate is 4.25%, which was earlier 6%, as Sir said. So today it's 4.25%. So you are liable, you have the right to recover 12.75%. That is compounded monthly on your principal amount. So many of the MSMEs don't know about it. So last month, one of my client approached me. He had a bill of 30 lakh rupees that was due. And he said, Aryan, please help me out. We have a recovery of 30 lakhs. So that bill was of 2017. We tried to calculate the interest, and the interest came out to be 22 lakhs 50,000, which is almost equal to the principal amount. So the MSMEs yet don't know that the government has made such a beneficial scheme for you that in case you are not getting your money on time, you're still getting interest, which is at such a high rate. Even the banks don't give this much interest these days. Then comes the rate of interest has already been discussed, the recovery of the due amount. So the recovery of this due amount is shall start from the 45th day. If you are not got your payment on the 16th day, you have not got your payment, the recovery of the amount, you can approach the MSME council on the 45th day, 46th day, and they will take your case. But there is a problem which sir has rightly specified, that we are still being covered under the operational creditors. The operational creditors are the last people who are cleared. Like if we go into IBC and the person who is managing the IRP, the resolutional professional will clear off the operational creditors at the last. For this also, MSME has made such a beautiful scheme that in case you get an award from the MSME Facilitation Council, you will no longer be covered as a operational creditor. You will become a secure creditor. You will become a financial creditor. So before clearing the operational creditors, the people who have the award will be cleared first. Now we'll just discuss the journey of the MSME. When you reach, am I audible? Yeah. So when you so sorry, I'm so sorry. There's a technical issue, right? So when you approach the MSE Facilitation Council, they will first try to get your matter resolved by conciliation. They will send an intimation letter to the buyer that you have not paid this amount to the supplier. They will give him 15 days to give this amount. In case he fails to pay this amount within 15 days, your matter will be referred to the conciliation, in which the board will sit and they will try to get both the parties on table and try to get your matter resolved before litigation or arbitration. They will try that your matter is resolved beforehand. They also don't want that the matters should go into litigation, because this is creating a very big problem for the MSMEs. Because if you don't have financial funds, your operations will get slow. Then what happens, in case this conciliation is failed, the MSE Facilitation Council will refer your matter to an arbitration. Now, this arbitration can be referred to an institution. They can also become an arbitrator and resolve your matter. The Act specifies that the arbitration award shall be given in 90 days. So, if you have got an award, if you get this award, now this award can only be challenged in the High Court. So the court system works like, we have tribunals, then we have district court, then we have High Court, then we have the Supreme Court. MSME Council has made such a beautiful system. They have skipped the journey of district courts for the MSEs. You can directly challenge this award in the High Court. And let's say the buyer has lost the case. In the award, the award says that buyer is liable to pay you the amount. Now, if he challenges this award, he has to deposit 75% of the amount to the court. So basically, your principal amount is very secure, as he's already deposited this amount. Let's say you have lost the case and you want to challenge. Then you are not liable to pay anything and you can directly challenge it in the High Court. So this is such a beautiful system that the council has done for us. Now, let us say that the matter is, we have got an award. Now, what should we do? We have got an award from the MSME Facilitation Council. Now, what is the next step that has to be taken? The next step is into execution. Like Dr. Kumar has already specified, that we should have a system in which the execution should happen through the council itself. And we do not have to approach the courts, because that's again a long process in which we have to go and get the properties attached of the buyer and then sell those properties to recover your money. Finally, these are the numbers that the current MSMEs are facing. In my personal experience, have seen that 30% of the cases are resolved during conciliation itself. maximum cases are resolved during the appointment of the arbitrator, because the arbitration is also a proper way in which you have to go through. It's also a litigation, but it's a time-bound litigation. In courts, the litigation is usually 3 to 4 years. In arbitration, the time specified is 90 days, which can exceed up to 180 days. Usually, an award, in my personal experience, we have got an award in 180 days. So I would like to conclude it that the best recoveries, the best way to recover the money is through arbitration, through MSME Facilitation Council only. You should not go through recovery proceedings in commercial courts, because that will take a long time. The cost of the litigation is too high. The cost that has to be paid to the courts is too high. But in the facilitation council, there is a very minimal cost that has to be paid to an arbitrator, which varies from 20 to 30,000. Now, what if a person has not specified to the ministry that they have a liability that has to be cleared to the MSEs? So now, due to the new notification, they have to tell the government that who are the MSMEs that they have to make a payment, and why that payment is not being made in 45 days. If there is any payment that has to be made that is beyond 45 days, they have to specify it. In case they have not specified this in their books, they are liable to pay a minimum 10,000 rupees fine. So now that this was the basic idea how you get recovery from the MSE facilitations. Now I'd like Shrey to talk about the recoveries through IBC proceedings.
Thank you, Aryan.
Thank you,
Thank you,
everyone.
Dr. Kumar. I'm very grateful that we could get this platform and speak to all of you, because I'm happy that you've given up this time on a Friday evening to listen to us speak about how we can help you recover your money back. And that we feel is very important for the state of institutions in our country to continue. So as Dr. Kumar has very generously called me, he's told everyone that I'm an expert in the IBC system. I'm very thankful for him for that. That's very high praise from you, sir. So thank you for that. I will introduce myself. My name is Shrey. I'm an associate partner at Sapphire Sage Law Offices. We're a New Delhi-based law firm. And in New Delhi, that's a main office. And besides that, we also have offices across the country. Now, before anything else, let me tell you a story, and then we'll proceed on to technicalities of IBC. I want to discuss what one client told me and how I was able to help him out, because the story might resonate with you. And I'm taking this path because Dr. Kumar mentioned one thing, that it's very hard for smaller MSMEs to recover money from larger companies. And that's one problem that the law has inadequately failed to address. So that's something we must talk about. So my story is this. My client comes to me. He says, Shrey, I was supplying services to this company for 3 years. And the system they had worked out, this company was a Fortune 500 company, very large company. The payment system they had worked out was you clear my client's payments every 6 months. So at the beginning of each year, my client used to take a loan, provide services. End of 6 months, go to the company, sir, please clear my bills. At that point of time, the manager in that company would come and say, okay, now you have to give me a discount, otherwise I will not release the funds on time. And my client is helpless. He has loans to pay back. His operation capital is fully tied up. So what does he do? He has to give a discount then. The manager is exploiting my client because he knows that my client needs that money in his hand right now. So that's the situation my client was facing. At the end of it, there was a lot of unpaid debt that my client had against this big company. We filed a Section 9 application in the NCLT, the National Company Law Tribunal, under the Insolvency and Bankruptcy Code. Luckily, because the company was such a big company, they said, okay, we cannot have these proceedings, we will settle. And luckily, my client got his money back. And that's the story I want all of you to have if you have money stuck from a large company, because that's where IBC really kicks in and can help you in a lot of ways. where maybe the MSME Act might fall slightly short of. So that's something I wish to talk about. Now, what I want you to take away from this session, from my 10 minutes here, is something very simple. I want you to have a practical understanding of the IBC so that next time when you go to a lawyer, you also know what are your rights and entitlements under the IBC. Second, I want you to know when the IBC can help you and when the IBC cannot help you. Because I'll be honest, MSMEs cannot, the IBC cannot help MSMEs in all situations. It is only that you use it in a specific set of situations with a smart strategic mindset, then you will get your money back. That's the basic idea. And finally, does the IBC have some beneficial provisions for MSMEs? The answer is yes, and I will tell those to you as well. So keeping this in mind, keeping our three objectives in mind, let me start with first, what is the IBC? What are things you must know about it? Because all of us do not know about the IBC, regardless of how popular this act has become in the past 5 years. So the first thing I must speak about is when did the IBC come into the picture? The year is 2016. The government of India cannot find a way to reform companies and resolve companies. Now, what does that mean? Before the IBC, there was this act called the Sikh Industries Act, Sikh Industrial Companies Act, SICA. Under the SICA, the idea was that our companies who cannot pay their debts have failed, and let's try to figure out a way to save them, because companies in the future will become the backbone of our economy. That's the basic idea. Now, SICA failed. That's without a doubt the situation. And in 2016, the IBC replaced it. Now, what does the IBC do differently? The first thing you have to understand why IBC is not your solution for all recoveries is that the IBC is not meant for recoveries. That's the first thing one has to understand. The point of IBC, the Insolvency and Bankruptcy Code, is to help a company get back on its feet. How? The government says, okay, Mr. Manager, the management, you are clearly incapable of running this company as you have racked up an X amount of debt that you're unable to pay your customers, your lenders, your borrowers, all of that. Therefore, let me replace you with the people you have taken money from, the banks, other lenders, all of that. So the banks, those lenders, they come into the picture, they take over the company from the management, and they, along with someone who's called the resolution professional, run the company. And the idea is to see if this company can now be sold to someone else who may run it better, and that money which will come in will be used to pay off the people the company owes money to. Or if that's not the case, then let's sell the assets of the company. Let's pay everyone. This is a failed endeavor. Nothing more can be done. That's called liquidation. So that's the basic idea. IBC is for resolution, not recovery. First thing we have to understand. So if anyone tells you that you can 100% get your money back through IBC, that is incorrect. That is unfortunately a lie. It is not meant for that purpose. But if you are smart, we may be able to use it for that purpose. And that's where good advice comes in. Now, let me tell you what are the situations where money can be stuck from an MSME to a company, to another company, and in what cases, what rights does the IBC ascribe to you? So there are three situations in which one can trigger something called a corporate insolvency resolution process, a CIRP, against a company. These three different situations are when one is a financial creditor, that's a concept under Section 7 of the IBC. The second is when one is an operational creditor, that's a concept under Section 9 of the IBC. And the third is when a company is a corporate applicant under Section 10 of the IBC. These are three ways to start IBC proceedings against a company. What does this all mean? First, financial creditor. When you as an MSME or someone else, you may give loans to, say, a friend's company, or you give loans to someone else's company because you're getting good interest back. Now, obviously, all companies cannot give loans, but obviously some companies can. So we'll talk about all of that also. So when you've given these loans or advances and all of that, you're someone who's called a financial creditor. So not all advances constitute financial debt, but we'll again speak about that in maybe another session. All of that is there. So the most classic example of a financial creditor is a bank who gives loans to people. So most MSMEs, I assume, may not be falling in that category. So that's done. Most MSMEs fall under Section 9, and that's called them being an operational creditor, which means what? That you've supplied either goods or services to a company. Everyone knows that this economy works on advances. You supply first, get your money back later. You supply your services or goods to a company. The company is unable to pay you back. And therefore, what do? You have a remedy under Section 9. And then, of course, we have Section 10, a corporate applicant, which is when the company itself says, okay, sir, sorry, I cannot pay any money to the people I've taken money from. Please do my CIRP. I am not able to run this company. That is a final classic case of what a CIRP initiation is. Now, what we can talk about after this is how, if you are an operational creditor, how can you take your money back from companies, and why the IBC is not the best mechanism for someone to take their money. I'll tell you why. Because what happens in an IBC proceeding is, suppose you will file your claim before the NCLT, Company Law Tribunal. The claim gets admitted by the NCLT. They will appoint a resolution professional. They will suspend the managing directors and the board of directors. And the financial creditors will form something which is called the Committee of Creditors, which will take over the company and run it along with the resolution professional. I know these are a lot of technical terms, but I hope everyone's still able to follow me. Unfortunately, as Dr. Kumar also highlighted, operational creditors do not form a part of this Committee of Creditors. So that's your first hurdle. You will not have a say in the running of the company. And a lot of times the financial creditors, the banks use it to misuse their position and actually downplay the debt of operational creditors and try to get what they want for themselves, because they're the least bit interested in getting your dues back to you. That's of no interest or consequence to them. So that's something to note. The second thing is the IBC mechanism is simple. Once the resolution professional is in place, he will invite claims, make a list of all creditors, then try to sell the company. And after the company is sold, pay off the creditors in a scheme. And in the scheme, as Dr. Kumar also highlighted, operational creditors are at a disadvantage, because first you will have your secured creditors, second you'll have unsecured creditors. All of these are obviously financial creditors that I'm talking about. Then you will have obviously along with them employees who have worked for the past year or so. And then after everything, after this long chain of people, after everyone's been paid, then will come operational creditors. And I'll be realistic and honest with you, in most cases, operational creditors do not get much money from the resolution process from the CIRP. Then why are we talking about all of this, and how can the CIRP process help you? I'll tell you how. The question is, some companies are solvent and have assets which are in excess of their liabilities, especially the big companies. So because they have more assets than liabilities, they do not want to give up their companies. And because they don't want to give up their company, when you file a Section 9 application before the NCLT, and if it looks to them that the Section 9 application may get admitted, they will actually come in front of you and ask for a settlement. Why? Because the consequences are manifold. If they lose this case in the NCLT will suspend the current board of directors and management, and will actually get other people to be in charge of the company. So for a managing director to lose his company over for what to him is a small amount compared to the size of his company, that is a very big thing. So those are the best case situations in which you can expect to recover some money back from such companies. Situations where there is a solvent company which has more assets than liabilities, because of which it will want to keep a hold of the company. And therefore, once you file the Section 9 application, you can use it as a leverage to actually enter into a settlement and negotiate with them and get your money back. I will recommend that if you use the IBC as a tool for recovery, please use it in this manner, because most of you will be operational creditors and not financial creditors. And therefore, even if you win your NCLT case as an operational creditor, it will not get much back to you, because all the money will be taken up by the banks who will come into the picture later, after the resolution professional appoints the banks as the committee of creditors and all of that. So that is my general suggestion to you, that this is the basic scheme of the IBC. And under the basic scheme, because unfortunately the system is set up against you in this manner under the IBC, your best case scenario is to force a settlement by using the IBC as a sword, as a hanging sword, of the fact that a person might lose his company. And in that respect, the IBC can help you in a lot of ways. And I have multiple clients who have been able to do this successfully. And it's only because that the other person was a solvent company and he was afraid of losing his company. So when you put his company to the sword, that is when he'll come up with your money. That's the situation. In other situations where the liabilities of the company might be more than the assets, where that person is okay with losing the company, I will suggest you speak to Aryan and go under the MSME Act, because he'll be able to help you better there. So that's my basic idea about when you can use the IBC. And I see that I'm running out of time, so I'll just speak quickly about a few benefits MSMEs have under the IBC. The IBC for insolvent companies is also a good way to start with a clean slate. Now, what does that mean? I mean, especially in recent times, because of COVID, demonetization, all of that, the industry is still reeling from all of those adverse economic impacts. And because of that, a lot of companies, at least I speak to a lot of clients who are distressed, are unable to pay debts even when they have the intention to pay back the people they borrowed money from. So in this situation, the IBC provides a clean slate to people under what is something called pre-packaged insolvency, which is an entirely new concept of law, which was introduced only last year in the monsoon session of the parliament. Under this pre-packaged insolvency scheme, you yourself go to the NCLT and say, okay, sir, my liabilities are much more than my assets. I do not think I am able to pay them. And because my existing loans are so much more, I don't think I can continue because I have to pay off those people first. I'm unable to get enough operational capital to run my business. So my company is basically gone. So in that situation, similar to the CIRP process, a resolution professional gets appointed. This resolution professional will ask you to submit the best scheme possible to resolve the company, where you might submit a plan saying, okay, I have 10 people I owe 100 crores to, but what I can at best manage is say 35 crores. And because those individuals also recognize that they have no option and that the assets of the company might be even less than say that 35 odd crore figure, I have no option but to take that haircut. The haircut is what we call in general legal parlance in this industry. So they take that haircut of 65% and they will give your company back to you. And now you start on a clean slate. Now you have no debts. You have successfully resolved your earlier liabilities. And now you can start afresh as a fresh business with fresh prospects and hopefully no more demonetization and COVID, and hopefully do your business well again. So that's the basic idea behind the pre-packaged insolvency process. Now, coming to all of this, I think what Dr. Kumar wanted us to speak about also was this lacuna in the law about where the IBC fails, where the MSME Act fails, and how distressed MSMEs can get something out of it. So that was my attempt at trying to solve this a bit by telling you that you as an MSME, your only hopeful remedy under the IBC, unfortunately at today at this stage, is if you're up against a big solvent company and you can tell them, sir, I'm going to get your company closed, so please you pay me back. And that is when you'll get your money back. Unfortunately, otherwise, your remedy is to go under the MSME Act and hope that they pay. But obviously, there are many, many challenges there also, though Aryan tries his best. So I'm sure he'll tell you more about the challenges faced there. Another thing, sorry, I'll just hand it over to Dr. Kumar and Aryan back. But the last thing I wanted to speak about is another benefit of the MSME provisions under IBC is simply the fact that when people bid for your company as an MSME, you can also bid for your own company under section 29A. So that's a big benefit given to people. So for MSMEs, you actually have a chance to save your company instead of selling your company to someone else under the IBC. So thank you all for the very patient audience. I am sorry I ruffled through so many concepts quickly, but I hope I was clear enough. And with Dr. Kumar's support, I'm sure we can answer all questions because I see that it's the time for Q&A. So thank you all. Thank you, Zumair. Thank you, Dr. Kumar. Thank you, Aryan. The floor is back to you. Thanks all.
Thank you, Shrey. Thank you. I think it was a wonderful discussion. And the finer points that you covered in your talk are really very relevant and very important and very educative. I think most of the people who are probably part of this program may not be aware about these finer issues, and you have very clearly spelled out various options. I mean, comparing both the provisions of IBC as well as MSME Development Act, it is now very, very clear from your discussion that MSME Development Act is a bit weaker for as far as recovery proceedings are concerned by the MSMEs. And IBC can, of course, prove to be a game changer, in fact, for them. So I will not go into, asking for further things, although I have noted down certain areas. But since there are, I think, a large number of questions and many people are interested to raise their questions from the experts, I would like to hand over to Zumair. Zumair or Sodamini, if you are there, you can raise, you can ask one by one so that all these questions can be covered. I suppose there are too many questions. Sodamini or Zumair?
Yes, sir. Good evening. This was a very, very intensive and a very, very important session. And you're absolutely right. We have a lot of questions today. So the first one is from Mr. Bhaskar Rao, who says, I have a facilitation council order. Even that is not honored by a CPU. And then I went to a district court and it is pending for the last 6 years. He even wrote to the Prime Minister, got a reply that the order of council has to be honored, otherwise taken to take the help of the district court. Now he's asking what can he do because he's already gone through these procedures and there's been no respite. So what do you advise for him to do?
Aryan, can you take up this question?
Sure, sir, sure. So I'm very surprised that execution is still pending from last 6 years. I'll have to first understand where are the proceedings stuck. In case they are just stuck to get the appointment of the person who will go and liquidate the assets or who will attach the assets. Are the assets attached? We'll have to understand the place where the matter has been stuck right now. I haven't seen any execution that has been pending from 6-7 years. Usually the courts, I know the proceedings are very slow, but still the courts clear off the executions and recover the money within 2 to 3 years. So if sir could just tell me where is the money, where is the proceeding stuck? Why aren't we able to?
Can I suggest Via Media can, can this question be put to you directly off this platform so that we can take up one by one? I mean, meanwhile, if the person who had raised the question can write to you or to on the platform, what is where it is stuck so that we can take up at a later stage.
Sure. So I'll put up my number in the chat box, then he can talk to me later on.
So Damini.
Good evening, sir. This is Bhaskar. Am I audible to you?
Yeah.
Yes.
Bhaskar, sir.
Yeah. Thank you. See, in 2014, I have supplied to a central public sector undertaking where the terms of payment is against delivery and they made the payment after 9 months. Then I had to approach the Felicitation Council then, and Felicitation Council has given an order. I waited for 3 months, and after that also they didn't do. Then I had to approach the district court, RR district court. I am calling from Hyderabad.
Okay.
See, the RR court, district court has given a warrant. There, they said, we have given a bank guarantee. And they didn't give the bank guarantee. After that, about 1 month after that, they filed a, appeal or something in the same court. And they have given a bank guarantee. Then we have challenged the bank guarantee. They have to put, deposit only in the form of cash, which is a settled law, and bank guarantee should not be accepted. But still then they are able to manage all these years. And then I went to the AP High Court with a senior most advocate by Mr. I think everybody must be knowing.
Sir, I'd like to intervene in between. This is a long discussion that we'll have to do. We'll discuss it on a later stage.
Yeah, if you give me your email ID or anything, I will
just put it in the chat box.
Grateful to you. I'm a senior citizen. And I don't know. See, even in the Supreme Court, these cases are settled. And I might have to, again, every small scale industry need to go the same process.
Yes, sir.
I have written to the a Prime Minister said, Prime Minister office said to me, it is a, the council what is binding on the central public sector undertaking, and they have to honor. If they don't honor the thing, you approach the, take the help of the local district court. Again, district court, high court, Supreme Court. I'm already 66. And 7 years is already passed. By the Supreme Court passes the order, do you think that I will enjoy the fruits of it? Is it the law that we are into India? I'm unfortunate to say this.
Mr. Rao, we are discussing the same problems. In fact, there are many others also who are facing these problems. So we are trying to find solutions and see what best can be done, because under the existing legal provisions, we are all suffering. Like you, we totally share your problem. So try to find out as to what exactly can be done. So if you can write your case directly to Mr. Aryan, I think some sort of solution can be worked out.
Yeah, I've put my email address in the chat box for the queries which are a little longer to resolve. We can have those on my mail itself.
Mr. Surendra Kumar Single, who has raised his hand. So Damni, can you request the gentleman to ask the question?
Thank you. With all respects to the two advocates, Dr. Kumar, you are all aware of many of my stories. The situation remains that particularly I'm talking of Haryana, but it may be for other states also. The Samadhan scheme has been diluted by Haryana. How it has been done, the Samadhan scheme, we do it on portal. It is done within a matter of 5 minutes. Thereafter, the Haryana Facilitation Council takes its own long road, years and years, not to talk of 90 days or 30 days. Now another blow has come from Haryana is that the arbitrators appointed by the council, they are restricted not to pronounce the awards. That is another blow. The awards are supposed to be in the form of a report from the arbitrator to the council, where it is heaped up. The files are in the racks and nobody is looking into those reports so to be made awards of it. This is the situation that Samadhan has been totally let it go for a shot. The situation is that from 2015, I started under the MSME Samadhan affair. My payment from public sector, I don't mind naming Visakhapatnam Port Trust, then Steel Authority of India, Bokaro, the Coal India subsidiaries, railways, all these are holding on because they have a panel of advocates, sorry, stretching to the advocate fraternity, that they had never advising them to pay. They say, okay, we go under 34. They create applications, IA, etc., and it is prolonging. So the situation remains that nobody is taking care of the execution is far.
Single साहब ऐसा है कि इसका that is why I mentioned in the beginning in my discussion that we should strengthen the facilitation councils so that the buyers are not able to take advantage of the existing weak provisions. So strengthening the councils means that you have to give judicial powers to them, and then only they can really give the orders. So if you can write these issues to power to SME, and we will surely take it up with the government, specifically for Haryana Facilitation Council, as you mentioned that they are diluting it. So can we go to the next one?
Sir, I would just like to add on something, but I have, in my personal experience, I have been seeing that the Haryana Council is working at a very good pace. They are I have had an execution done in the Faridabad. The execution happened in 6 months only. So I am a little surprised that his case has been stuck, but Haryana Council is working at a good pace. This is my personal experience.
Mr. Singhal can write to you if you can help resolve this.
Sure, sir. I'll try my level best.
I would request everybody to be a little brief with their issues since we're addressing a lot of questions over here. Mr. Patel is next. Sir, if you could please ask your question.
Yes, thank you so much for allowing me to ask the question. I have a couple of questions, but I will ask only 1 or 2 questions. I have one question for Shrey Patnaik. Sir, you told about the IBC. So I have one query, sir. अगर 24 मार्च 2020 के पहले का अपना कोई डिफॉल्ट है एंड वो बिलो 1 CR है, लेट से 50 लाख का डिफॉल्ट है 24 मार्च 2020 से पहले का, तो क्या हम उसको आईबीसी में फाइल कर सकते हैं? एनसीएलटी बेंच हमारे मैटर को एक्सेप्ट करेगी या रिजेक्ट करेगी सर?
Unfortunately, उस पे the law is settled now. It'll have to be above a crore. That's very unfortunate. The case should have been filed before the amendment came in. Because of settled law now, the Supreme Court and NCLAT decision on this are clear. So I'm so sorry for your case, but no, that will not be possible.
Next we have Ms. Shifarika Sharma. Can you please ask your question?
Yes, please. We are in MSME, and since 2019 December, that is just a little before the COVID, we became stressed due to 5 big public sector companies. I don't mind naming: Bridge and Roof and L&T, Siscol, Soma Rodis, which is a Italian-Indian tie-up. They owed us at least about 30 lakhs each, so amounting to 1.5 crores. Our matter got taken to IBC, and we had to go for a settlement. And then came COVID. We are a manufacturer, and the 3-4 lockdowns completely, our operational crunch is there. Now people file cases against us. They drag us to, and one case was filed before 24th March, which is amounting to about 23rd. Now, what is the protection offered to MSMEs when they are, they can't get their recoveries from these big companies? And in the meantime, I get cases and I get service providers at my doorstep.
Right, if I may.
Yeah.
So from what I understood, you already have settlements from bigger companies.
No,
But
sir.
just
No,
to be
sir,
clear,
no, sir.
is that at a substantial haircut?
No, sir. No, sir. We had 5 companies which owed us a big amount. Chote to bahut hai.
Yes.
But these 5 companies cumulatively owed us about 1.57 crores in December 2019. Then one company took us to IBC and we settled with them because we were expecting payments 1-2 mahine mein aa jayegi. That is what we were assured by their managers. Bas abhi aa rahi hai.
So just to be clear, you owed those companies 1.5 crores.
No, sir. They owed me.
They owed us, right? They owed you, right?
Till date,
right.
that money has not come.
Oh, right.
And because that money didn't come and the COVID lockdown, so I went further and further into cash flow problem. Now, who protects me? Because naturally the interest is piling up on this company I did the settlement with, and kabhi koi samadhan mein hamare khilaf, kabhi wo. So we kind of become culprits just because we didn't get our receivables.
Ma'am, from what I understand, you have to take immediate steps, at least put in something, some sort of a claim. I think Aryan will advise you better on whether it should be.
I think I would like to do that, but wahi hai na ki ya to company chala lo ya lawyers pe kharch kar lo. It's a very.
The basic idea is you have to quickly get your money back and prolong the payment of money to whoever is claiming from you. The game is of buying time, from what I understand.
So I'll contact.
And the money will come sooner or later.
And thank you. I will contact Aryan.
No problem.
Thank you.
Thank you.
Moving on to Ms. Sunita Padmaji, if you could please ask your question.
Good evening, everybody.
Good evening.
Hello. Yeah. Good evening. So it is a very nice session. I used to attend all the sessions you are organizing, and it is a very informative information I'm getting. Being an MSME company, our main we are acting as a subcontractor to Sterling Wilson in Nagpur project, where we have filed a MSME in Kanpur with Kanpur Facility Council. And one of our contractor in this project only has provided us the services, and he has filed a case in Delhi MSME Council. Since our Kanpur Facilitation Council is not providing a fruitful response, and though there is no any hearing, only 2 hearings were there before lockdown. Thereafter, there was no hearing. But here, Delhi MSME is monthly. He is conducting the notices we are getting, and hearings are going on. And we are telling the MSME Council of Delhi that since our main contractor is not paying us in the same project, that's why we are not going to pay this contractor. But he is not entertaining our request. He's telling this is not a back-to-back contract, you have to pay. When we are not receiving for the same project from our main contractor, then how can we can provide our vendor or this? This is the main question, and we would like to know how to address this one.
Aryan, can you help?
Sure, sure. So she's very right that the Kanpur Council and the UP Council basically is a little bit slow, but the Delhi Council are, as per my experience, they are the best. As the SDMs are the directors who are gonna help the MSMEs. But now I am a little confused that whether your the council, Kanpur Council is not even working on it. You'll again have to buy time from the council, MSME Council in Delhi, and you might be able to include them as garnishes. But before that, you will have to first get an award in your favor. Before that, you may not be able to include them as a garnishee also. So in this also, you will have to buy time first from the Delhi Council, get your award from the Kanpur Council, and then include the council. Then when they go into execution, you can bring the award here and say that we have to get the money recovered from them, so they can directly take it from the garnishes. But this can happen only in execution code, not in the facilitation council. Facilitation council will work. You don't have a back-to-back contract. They are very right that in your current contract, there was nowhere written that when you will receive payment, then you will make the payment. So they are totally right in this part. So you will have to buy your time first, get an award from the Kanpur Council. When they get into execution, then you can include them as garnishes.
Yes. So Damini.
We're going to take the last question for the day. There are a lot of questions. So I would really like to request the participants who have queries to please reach out to our speakers on the email ID they have provided in the chat box. We will be putting up a copy of the recording of this webinar on the YouTube channel of Power to SME, so you can review it there. But last question of the day from Mr. Bhavesh. Please ask your question, sir.
Hello. This question is for Mr. Aryan Arora. Hello.
Yes, please carry on.
Yes, sir.
We can hear you. Yeah.
See, Mr. Aryan Arora, I have recently come across one clip of MSME that it says that it will not help any traders to recover the money from anywhere. Only manufacturer and service provider will have a benefit of registered under MSME. But traders are not at all MSME will not at all help the traders. I am basically very small traders based in Maharashtra, and I'm looking forward for a help from MSME. My lot of money is stuck up to one contractor, and he is hardly paying some bits and peanuts to me, and he's not at all willing to pay me. But as and when he gets the money, he will pay me. That's all. I don't know till when he will pay me. A lot of money is outstanding.
Sorry to say, sir, but I might not have specified it earlier, but this facilitation is only for the manufacturing sector and the service sector till now. There is no notification for the traders yet, and the facilitation council won't help you regarding this. You might be able to issue your case also, but then it will get rejected because the facilitation council does not have jurisdiction over the traders till now. There is no notification that has come till now. There might be a notification in future, but till now we are not able to help you in the recovery from the MSME facilitation. There are more modes of recovery. Your money has not your money has not become bad debt for sure, but council won't be able to help you, and they don't have jurisdiction. They don't have power on it.
Damini, can I make a request, Damini?
Yes, sir. Yes, sir.
In fact, if there are some more questions, and if we can spend another 5 minutes, if you agree, then we can maybe dispose of other questions also very briefly, one by one, with short answers.
Yes, I'm going to pick up some questions from the chat box.
Yeah.
Mr. Jayan Sheth has to say that one of his clients is a cooperative housing society in Navi Mumbai. He has offered repair services to their group of buildings. They insist with MSMEC that they can be pursued. Legal action is taken by a cooperative court. What is the fact? Can they be tried under MSME Delayed Payments Act?
Yes, I heard that they are they are providing repair services, so they come under service sector. They are allowed to approach the facilitation council.
Yes, that is what I also would like to say. As long as they are micro and small enterprise, they can always go to facilitation council, irrespective of any kind of borrower, whether it's a company, private, cooperative, or any kind of borrower. Okay, so Damini.
I'll just like to add on one more thing.
Yeah.
It doesn't only conclude towards the government enterprises or the Indian enterprises. Even if you have a foreign buyer, we can still fight a case under the facilitation council.
Absolutely.
It's not bound to India only.
Right. Right. So Damini.
How to use IBC for recovering arbitral awards from PSUs like SAIL, CIL, railways, etc., whose empaneled advocates initiate long-drawn litigations.
Right.
Yes, Shrey.
So I see that question is from Mr. Kumar, I think, if I'm not wrong. In any event, if you have an arbitral award, please feel free. If the award is of more than a crore, please again feel free to go to an NCLT. Again, the idea is simple. If there is a risk that a PSU might go under, and which I don't think has happened yet. I think the closest we came to was maybe Air India and Hindustan Antibiotics, which almost went under. But otherwise, I am personally not aware of any PSU which has had a CIRP proceeding commencing from a Section 9 or Section 7 application. I think because these PSUs are massive, in case you have such a claim, please go for it and try to get a settlement. I have found most PSUs to be reasonable after you put them in a spot. So please put them in a spot. Please get your money back. That's my suggestion.
Yes. So Dominic.
Arbitration cases under process as per the clause in MOU with our client. Can we quote or use the provisions under MSME Act in the arbitration case?
So I am a little confused. You are saying that then in the agreement, there's an arbitration clause, but the facilitation council will automatically send them into arbitration. You might not have an arbitration clause. If you want to go through the arbitration council, that's also valid, but then you will not be entitled to recover the interest. The interest is only given under the facilitation council. The 12.75% interest. I am not sure whether the arbitrator through the arbitration, through your contract, if you go to the arbitration, he might listen to the interest, but through the facilitation council, you are entitled to recover the amount with interest. And this is also this also has arbitration only. They'll first try to get the conciliation done. In case you're not able to get the matter resolved through conciliation, then they'll appoint an arbitrator.
Right. So thank you so much for that. With that, we've covered the larger questions for today. हमारे पास आज इतने questions आए हैं कि इन सबको cover करने के लिए तो एक अलग से ask me anything session करना पड़ेगा, which of course we would like to plan with you. It's been thank you to both our speakers. It's been an immensely successful session. For those of our participants who have more questions, I request you once again, the email ID for our panelists has been given in the chat box. Please feel free to reach out to them directly. In fact, we have a couple of questions asking if whether there is any schedule of charges for advocates on the panel today. So I would really suggest please reach out to them directly. The recording for today's webinar will be available today in about an hour or two on Power to SME's YouTube channel. I request you to please check there by 7 p.m. or so. And with that, I hand over to you, Dr. Kumar.
Thank you, Sadamini. Thank you very much. It was indeed a wonderful session with two of our experts, Mr. Shrey and Aryan. Both of them really expert in their fields, and the finer things that they mentioned, really some of the things even I also didn't know. So thank you very much. And so Damini, we need to hold maybe one or two more similar programs in future, so that the participants who have not been able to, discuss their issues, they also get the opportunity, and maybe more people can join this forum, so that we can really bring out not only awareness, but also the way forward and the recommendations which we can make to the government. So yes, thank you very much. Yeah. Yes. So thank you very much. I think I must thank everybody, the co-panelists and the participants, and also the organizers. So Damini and Zumair both of them have done a wonderful job. So thank you all. Thank you very much and take care.
Thank you so much, Dr. Kumar. Thank you everyone for the time. I am so sorry that our answers to your questions would not have been very satisfactory, but we didn't have too much time. So I hope when you give us a chance to give more time, we'll figure something out. Thank you so much.
Yes, yes.
Thank you, everyone. Thank you very much. Thank you, Mr. Kumar, Dr. Kumar. Thank you for the introduction, and thank you for giving us this opportunity. And we are very obliged to speak in front of the council. Thank you.
Thank you.
You know, when Dr. Kumar calls you an expert, you're doing something right in life. So thank you so much for that.
We're still trying. Thank you. Thank you.
Okay.